We hear you, but we don't see you. Oh,
Okay.
we see the clerk now. Okay.
Give me a second. I call this meeting to order.
Bonjour.
And the motion adopted on September 22nd. The committee is meeting to begin its study on the subject matter of Bill C-28, an act to amend the criminal code, self-induced extreme intoxication. Today's meeting is taking place in hybrid format pursuant to the House Order of June 23rd, 2022. Members are attending in person in the room and remotely using the Zoom application. I'd like to make a few comments for the benefits of the witnesses and members. Please wait until I recognize you before speaking. For those participating by video conference, click on the microphone icon to activate your mic, and please mute yourself when you're not speaking. Interpretation for those on Zoom, you have the choice at the bottom of your screen of either floor, English, or French. For those in the room, you can use the earpiece and select the desired channel. A reminder that all comments should be addressed to the chair. For members in the room, if you wish to speak, please raise your hand. For members on Zoom, please use the raise hand function. And the clerk and I will attempt to do our best to put you in the speaking order. For your information, all tests have been, sound tests have been successfully performed with our witness, including ringer tests. And I'd like to welcome our first, before I begin, I just have a couple cue cards. So when we have 30 seconds left in your time, whether it's the witnesses or the members, I'll raise the cue card. And when you're out of time, I'll raise the out of time cue card, the red one. Please be mindful of that so I don't interrupt your thought. And when I put the 30-second, if you can kind of wrap it up at that point. I'd like to welcome our first witnesses appearing today. We will have Holly Foxhall, Program Director from Action Now Atlantic. I think she's via video conference. Professor Hugh Perron from University of Montreal, also via video conference. And from Manitoba Prosecution Service, Amy Kotler and Michelle Joule, the Executive Director. So we'll begin for 5 minutes of each organization, and we'll begin with the Manitoba Prosecution Service for 5 minutes.
Thank you, Mr. Chair. Good morning. We'd like to thank members of the committee for allowing us the opportunity to speak to you today. Manitoba's Justice Minister Calvin Gertson's actually been deeply engaged on this issue. He's urged legislative action following the loss of the previous Section 33.1. He's offered to help in any way possible, so we're here hoping that we can offer some assistance in your deliberations on this complex issue. With me is Amy Kotler, General Counsel in our office, Senior Counsel in our Appeal Unit, and Counsel that represented Manitoba in Supreme Court in both Brown as well as Chan and Sullivan. It has been said a number of times in these deliberations that cases involving extreme intoxication are rare. As the office in Manitoba with conduct of criminal prosecutions, we can agree that in relation to overall offences, these cases are rare. But that does not mean that they arise infrequently or that their impact is not significant in our communities. Several such cases are before the courts in Manitoba. In one that resolved just last week, an accused fired a shotgun through the front door of a random house, nearly striking a child. He had consumed crystal meth and was totally incoherent. Officers noted that he ate his own feces in the interview room following his arrest. In a previous case that went to trial last year, the accused jumped into a random stranger's vehicle at a gas station and stabbed her to death. He was shirtless, barefoot, and described as speaking in tongues. The trial judge observed that he had taken several drugs, including, again, crystal meth, and that his behavior was indicative of someone in a different reality and not in touch with this world. In a third case, pleas had been entered in relation to a homicide. The matter was set this past May for sentencing. Instead of delivering the sentence, the sentencing judge invited the accused to withdraw his guilty plea in light of the decision in Brown. He did so, and we now have this matter set awaiting trial in the new year in September of 2023. We have other cases like this before our courts, and this is an issue that we will be litigating. I raise these examples in order to emphasize the importance of a law like Section 33.1. It shows that the justice system is capable of responding to the threat posed by powerful mind-altering substances that lead to extraordinary acts of violence, often against random victims. A well-established body of medical evidence links widely available drugs like crystal meth to toxic psychosis, paranoid delusions, and violent aggressive behavior. People taking these drugs frequently exhibit suicidality, homicidality, psychosis, abnormal behaviors and movements. The justice system must be able to respond in the face of such violence. Not only does it risk the lives and safety of the community members that we serve, but it jeopardizes public confidence in the administration of justice and the rule of law. At the same time, however, it is important that the law recognizes realities of addiction, particularly for marginalized communities grappling with intergenerational aftermath of colonization. If we're committed to advancing reconciliation, our laws must criminalize morally blameworthy behavior, not addiction, not poverty. And for this reason, we believe the answer is not to have an offense of extreme intoxication. We support the decision to root liability in negligence, and particularly to consider steps taken by accused consuming intoxicants to avoid placing others at risk when determining whether there has been a marked departure from the standard of a reasonable person. This balance acknowledges the challenges facing many members of our community, while still insisting that whatever our circumstances, we must still take reasonable steps to protect one another from risks caused by our own dangerous acts. We appreciate that some may feel that that weakens the legislation. Respectfully, we would suggest that the decision in Brown makes it fairly clear the need for this kind of approach. And more fundamentally, a law is not weaker because it is humane, balanced, and fair. In our submission, we believe it is stronger and, of course, more likely to survive constitutional scrutiny. In discussing enforceability of the legislation, we will close by briefly discussing how we propose to obtain convictions under the new section. Virtually all cases we are seeing where the accused degree of intoxication approaches the extraordinary level contemplated by the legislation involves consumption of one or more powerfully dangerous drugs whose effects can reasonably be expected to include dissociation, psychosis, and violence. While verdicts in individual cases will obviously turn on their facts and the evidence that we're able to call, we feel there is a case to make that an accused consuming these dangerous substances, particularly in excessive amounts for a prolonged period of time, in combining them with other dangerous substances or taking unidentified substances from an unknown source, he or she courts a foreseeable risk that their actions may lead to a violent loss of control that harms another person.
Thank you, Ms. Jules. Hopefully we'll be able to extract some more out of the questioning.
Certainly.
I will next go to, for 5 minutes, to Holly Foxall, the Program Director for Action Now Atlantic.
Thank you so much, Mr. Chair, and thank you so much for having me here today. My name is Holly Foxall, and my pronouns are she, her, and today I'm joining you from Mi'kma'ki, the ancestral and unceded territory of the Mi'kmaq people. I'm the Program Director of Action Now Atlantic, which is an initiative and campaign to end sexual and gender-based violence at universities in Atlantic Canada through education, advocacy, and community engagement. We've been fortunate enough to receive funding through Women and Gender Equality Canada to launch this project. Our mission is to promote a culture of consent on campus through virtual workshops, the development of educational material and resources, as well as our own youth advocacy network. A big part of our work is connecting and collaborating with other organizations and individuals and taking a cross-provincial approach to addressing the issue of sexual violence on campus in Atlantic Canada. The inspiration for Action Now Atlantic grew out of my personal frustrations around my own experiences and the experiences of my friends and peers while attending post-secondary education. I completed my undergraduate degree at Queen's University and remember feeling a culture both on and off campus where sexual violence was normalized and many people didn't understand or respect consent. When I graduated and moved home to Nova Scotia, I remember seeing news stories about similar campus cultures and attitudes here. I read of many instances of sexual violence on campus where universities mishandled the cases and caused even greater harm to survivors. Unfortunately, sexual violence is still a prevalent issue within post-secondary communities. We know that 1 in 4 women experience sexual assault while attending a post-secondary institution, and 71% of Canadian post-secondary students have witnessed or experienced unwanted sexualized behavior during their time at post-secondary. The first semester of university is meant to be an exciting time for students returning to school, but it's a notable time when it comes to sexual violence on campus. The first 8 weeks of each fall semester are referred to as the red zone, when 50% of all sexual assaults on campus will occur. This is a time of increased vulnerability on campus when there are many new students who are often away from home for the first time and without their usual support systems. It's critical that information around sexual violence and the laws relating to intoxication and assault are understood correctly by all members of our society, but especially those who may be engaging in sexual activity, drugs, and alcohol. When the news of the Supreme Court ruling on extreme intoxication was announced, there was serious concern about what the ruling would mean for campus communities and all survivors of sexual and gender-based violence. In our society, intoxication is often used as an excuse for those who cause harm and a way to delegitimize survivors who do come forward. I, along with so many Canadians, had many initial questions about this ruling. Would it provide more protection for those who sexually assault people and create even greater barriers for survivors to come forward? Will the ruling impact the ability and willingness for survivors to report cases of sexual violence? And do people who cause harm know that drunkenness alone is not a defense in sexual assault cases? While the initial ruling got a lot of press, Bill C-28 and what it actually means received far less interest or time in the media. How people understand laws can greatly impact behaviors and cultures within our communities. So it's essential to have clear and easy to interpret information around these laws. This will build greater trust in our government and legal institutions. I'm not a legal expert, so I'll not try to comment on the technicalities of the initial Supreme Court ruling and Bill C-28 and what it means from a legal perspective, but I do hope to bring a youth perspective to this conversation. I can share reasons why many survivors don't trust legal institutions and why rates of reporting sexual violence are so low, as well as what the initial reaction was within campus communities to this ruling and how it may impact campus cultures, even with the implementation of Bill C-28. I'm someone who cares deeply about the safety and well-being of young people and especially survivors of sexual violence. Anything that has the potential to create opportunity for people to cause harm and build further barriers for survivors is something that we need to think critically about. And how our legal institutions and governments share this information to the general public is important for community safety and overall trust within our institutions. Thank you for your time.
Thank you, Ms. Foxall. Next, we'll go to Professor Hugh Perrant from University de Montreal for 5 minutes.
Parfait. Tout d'abord, juste.
First of all, I told you I had COVID. So at some point I may be interrupting my presentation, so I'm sorry. Without further ado, I'll start. In law, extreme intoxication can manifest itself in 2 ways. First of all, sometimes, but rarely so, extreme intoxication can disrupt a person's consciousness to the point where he or she is no longer to act consciously. In this case, the person can move but is not aware of the actions. They are like a robot. This is called extreme intoxication and is similar to automatism. Substance-induced delirium is an example of extreme intoxication similar to automatism. This is the diagnosis used by the Supreme Court in R versus Brown. The second manifestation of extreme intoxication occurs when the person is under the influence of delusions and or pronounced hallucinations as a result of voluntary drug use. In this case, the person remains physically aware of their actions physically, but unable because of the psychotic episode to judge the nature and quality of their actions or to know that their actions are wrong. This is called extreme intoxication, which is close to insanity. To understand the distinction between the 2 types of extreme intoxication, consider the following example. A takes cocaine and develops delusions of persecution. A is convinced because of his delusions that his neighbor is a member of a criminal organization that wants to kill him. To avoid being killed, A picks up a gun, goes to his neighbor's house, and shoots him. Here, the accused is not in a state of automatism. On the contrary, A is fully aware of their actions insofar as they know that they have a gun in their hands and that they have their finger on the trigger and that they are firing in the direction of the victim. Far from being unconscious, A's act is directly in pursuit of the goal imposed on him by his delusions, that is, to save his life by killing the attacker. Although he is able to consciously control his conduct, the accused is not able, because of his delusions, to know that his actions were wrong. Hence, the presence of extreme intoxication bordering on insanity. Now, let's look at extreme intoxication as a doctor. The presence of psychotic episodes without disturbance of consciousness is a well-known manifestation of drug intoxication. Discussing the symptoms associated with acute intoxication and the importance of considering psychotic episodes without disturbance of consciousness, Dr. Marie-Frédérique Allard, an eminent psychiatrist, writes as follows. As a forensic psychiatrist for many years, I regularly assessed people who have presented with severe intoxication during the commission of a crime. Altered consciousness may occur in very specific situations. For example, severe alcohol or benzodiazepine intoxication, delirium like in the Brown ruling, etc. But this is not the norm. This is rare. When there is acute intoxication by drugs such as amphetamines, and cocaine, substances often linked to behavioral disorders, the state of consciousness is not altered. On the contrary, psychostimulants have the property of stimulating alertness. These substances also have a high potential to induce psychotic symptoms that may even last well beyond the period of intoxication, as the first speaker said a few minutes ago. When individuals suffer from a psychotic disorder induced by stimulants, cannabis or other substances, they generally remain able to control their actions and they are aware of their behaviors. The substance-induced loss of contact with reality primarily affects their ability to know that their actions were wrong in the circumstances. Hence, it is important to add extreme intoxication when we discuss. It's important to clarify extreme intoxication as automatism and extreme intoxication as insanity. By limiting the definition of extreme intoxication to automatism-like cases, the government focuses only on one manifestation of extreme intoxication, automatism. It leaves out cases of intoxication that do not affect the defendant's ability to consciously control his or her conduct, but which prevent the defendant from knowing that his or her act is wrong. There are things I don't write. In other words, the person finds themselves in such a state and cannot plead extreme intoxication because this section only deals with extreme intoxication that is akin to automatism. So here, a decision has to be made, and of course it goes before the cases, and section 33.1 would be the same like the old version. I have a report on that, but I can't say much about that now.
Mr. Perot, I'll go to the first round of questions, beginning with Mr. Caputo for 6 minutes.
Thank you very much, Chair. I'd like to thank everybody here. First off, Professor Parent, I'm sorry to hear of your illness, and I hope that you get better soon. Ms. Foxall, I just want to very briefly mention something. I really do appreciate your work. In fact, my wife does a lot of the same work that you do. And one of the things, she recently attended a seminar where the focus was no means no. And in fact, I think we have to start shifting the narrative as you are to only yes means yes. So I really do appreciate that work, and I wanted to put that on the record. To the Manitoba Prosecution Service, thank you for being here. You know, it's so often when we're here that we debate things in the abstract, and we don't hear from people on the ground who are actually impacted. So I encourage this committee and all committees to bring people here who are on the ground, because this is a unique perspective, and it may be the only perspective we have from people who are in the trenches, in the prosecutorial end of things. So I really do appreciate that, and I'm gonna start there. And Mr. Kotler, you have, did I pronounce that correctly? Kotler?
Well, it's Kotler, but anything is fine, really.
Okay. Kotler, I'm sorry. Mr. Kotler, you're obviously a distinguished appellate litigator, and we're so fortunate to have you and Ms. Jewell, somebody at the top of your organization. Thank you. And I'm going to ask you this question. It's a bit of a nerdy question, but it's about foreseeability of harm versus foreseeability of loss of control. And you may have anticipated us going there with this. They're two very different things, right? I'm just wondering if either or both of you could comment on that distinction. The legislation, I don't have it right in front of me. My recollection is it's foreseeability of harm, as in a reasonable person must reasonably foresee that the self-induced intoxication would result in harm. Can you comment on that distinction and whether it's material?
Sure. So first of all, the legislation refers to both. And you'll see in subsection 2, it says that in determining whether the person departed markedly from the standard of care, the court must consider the objective foreseeability of the risk that the consumption of the intoxicating substances could cause extreme intoxication and lead the person to harm another person. So you have the reference to loss of control and to harm. We took the position in the Supreme Court that the fault element of the offense should follow the physical element, and so that the risk at issue when discussing negligence should be the risk of a violent loss of self-control as opposed to simply a loss of self-control. And there are a number of paragraphs in Brown that suggest that the court took a similar position. That said, we don't want to overstate, and I think you may not want to overstate that requirement, because in many cases, bringing yourself to the point where you can no longer control your body will strongly imply a risk of violence. If you're not in control, then anything is possible, and ipso facto, that's going to include violence, right? If someone who takes their hands off the steering wheel of a moving car can hardly be surprised when the car runs into somebody. Monsieur Fortin, I believe you've made similar observations in the course of previous hearings. But, you know, you can foresee a case where that isn't the situation. For example, where a defendant is using a drug like crystal meth at a safe consumption site, where there is a foreseeable loss, a foreseeable risk of a loss of self-control because you're taking a drug that removes that self-control, but where that person reasonably expects that they're going to be supervised and kept away from other people. So there isn't a foreseeable risk of harm to another person. And in such a case, depending on the facts, it might not be fair to conclude that that person was negligent and therefore liable for what happened. For example, if there was a failure of supervision or, the door was left unlocked. So to finish on this, the current wording of the legislation, I think, arguably does place unnecessary emphasis on the foreseeability of violence as a standalone requirement. The use of the word "and" generally is a strong signal to judges interpreting legislation that these are independent elements, as opposed to simply a way of describing what kind of losses of self-control the legislation is looking to address. So that might cause a concern if a judge were to interpret the legislation as saying, okay, I need proof that this particular substance in this particular dosage will cause people to become violent, because the Crown's rarely going to have precise information about the toxicology of what an accused was taking. Also, street drugs are unpredictable. They're constantly evolving. It makes it hard to get expert evidence, even if you did have that kind of information available to you. So if you are looking for ways to amend the legislation, you may want to consider something along the lines of foreseeability of risk of a violent loss of self-control, or in the Brown decision at paragraph 19, Justice Kassir refers to the choice to voluntarily consume intoxicants where that choice creates a risk of violent crime, as opposed to setting out risk and harm, self-control and harm as independent requirements that both need to be proved beyond a reasonable doubt.
Okay, thank you. That's very clear.
Thank you, Mr. Garbudo.
That was it. Okay.
Apologize.
Sorry.
Ms. Diab for 6 minutes.
Thank you very much, Mr. Chair, and thank you and welcome to all our witnesses. We've started the study, it's been a couple of times now, and the witnesses have really, that we have encountered, has just sort of spoken to how technical and the law is, and particularly here when we're talking about the criminal law and those particular sections of it, and really how it affects people. So thank you very much for coming to sort of aid us in our deliberation as we study the afterthought of this. Ms. Jules, I have questions based on where you kind of left off. You began by saying that Manitoba is urging the government to act, and in fact, it was an urgency that there was a gap that was left in the system at the Supreme Court of Canada when the decision was made. And then you further, went to a point where I actually very much appreciate, and you recognize that there's always a balance that needs to be made when making policy, when creating laws, between the justice system needing to respond, but also recognizing certain realities that we have in our society. And I think you left off with trying to propose how you believe, or Manitoba believes, you can still get convictions. And you were not able to complete that. Would you mind starting us off, going back to where you kind of left off and talking to us about that, please?
Certainly. I think we had indicated that we believe the inherent dangerousness of certain drugs themselves will be evidence that will assist us in terms of the effects that we would expect everyone to have some concept about and can reasonably expected to potentially lose control and have a violent loss of control. We anticipate there would be expert evidence that we would call in many cases. And the individuals that we're talking about may also often have a history that we're aware of, a history that has been introduced to the court previously. We often hear submissions in court from defense counsel when explaining their client's behavior that speak to this Jekyll and Hyde change in behavior when they've consumed a dangerous drug. So we may very well have history to call to demonstrate how foreseeable it was for this particular individual that they would act in a violent way if they were consuming and becoming extremely intoxicated. So we do think that it is a foreseeable risk in many instances, and that we will have evidence put before the court of that in terms of the negligent action of the individual when compared to the reasonable person. We are confident that we can make this case in front of judges and juries, that those that negligently jeopardize the safety of other members of our community can be held accountable through this legislation.
So just to clarify again, and that goes to Ms. Foxall's kind of point, and it's one that I kind of questioned on the last time I had an opportunity on the committee. need really to be very clear, very concise. There's been a lot of misinformation, particularly about this after this has come about. And in my opinion, there's been gross amount of misinformation, particularly online for young women. So the particular need to really be clear and not talking so much legalese and plain language. In law, no matter what the law is, but particularly in these cases. So can you just for the record again, let's be clear that anybody who puts themselves negligently in a dangerous state in which they cannot control their actions cannot think that they should be escaping a conviction if they hurt somebody. Do you know what I'm saying? Can we sort of?
I do. I think I know what you're saying, and I think that again, I don't think that we can guarantee in all cases that each case will turn on its facts and the evidence of the case, but we do think that the legislation can get us there in terms of being able to obtain convictions. And I will say, in listening to Ms. Foxall, I also would encourage a communication strategy to reach the public so that there is an understanding of the risk that individuals have and the expectation of that foreseeability when they're in those circumstances. I also had young adults in university when the decision came out, and within 24 hours they were contacting me saying, "Mom, is it true that you can sexually assault someone if you just get drunk enough?" So I do appreciate very much what Ms. Foxall indicated and the need for clarity, as well as perhaps, as I said, it's not really for me to say, I suppose, as a prosecutor, but I think a communication strategy so that the law is clear to those who may face this jeopardy.
Thank you. And Ms. Foxall, just to end before
Sorry,
I end.
Ms. Diab.
Thank you for being here, and thank you for coming from Nova Scotia, I guess, online. And maybe someone else will come back and ask you what I was going to ask.
No problem. Thank you, Ms. Diab. Next, Monsieur Fortin for 6 minutes.
Merci, Monsieur le Président.
Thank you, Chair. First of all, I would like to thank all the witnesses who are here this morning, Ms. Jules, Mr. Cutler, Ms. Foxall. Thank you for your presence. Mr. Parent, thanks for your presence. Mr. Parent, I understand that you were kind of asked to present quickly, but very often we have a time management problem. So I would like to hear you more this morning. So I would like to give you some of my time for you to complete your presentation. So you can go ahead and tell us what you wanted to tell us, Mr. Parent. Your mic is closed. We can't hear you, Mr. Parent. Can you hear me now? Yes, thank you. What I'm saying is that by limiting the definition of extreme intoxication akin to automatism, the section leaves aside the most severe and most frequent manifestations of extreme intoxication, all psychotic episodes, which the person does unconsciously. So Section 331, as currently framed, leaves aside all these episodes. I'll read you a passage of the Brown ruling. According to Justice Kazira, it should be noted that extreme intoxication akin to automatism is a demanding defense requiring the accused to show that his or her consciousness was diminished to such an extent that he or she had no voluntary control over his or her action. This is not the same as a psychotic episode where voluntariness is the physical sense remains intact. So everyone who takes drugs, and that's the majority, it's 95% of cases of extreme intoxication, there's no diminution of consciousness. Those who take cocaine feel that they are being persecuted and subsequently could kill someone. This has nothing to do with automatism. So 33(1) will not apply to these people in such circumstances. And at that time, the person could plead extreme intoxication using insanity and will be freed. Section 331, it's limited to a single facet of extreme intoxication as stated by the Supreme Court in Brown. And that is the rarest manifestation of extreme intoxication, cases where it leads to automatism, the person becomes like a robot. That is extremely rare. The Quebec Psychiatry Association, as well as the Canadian Association, may tell you that when we talk about extreme intoxication, in 95% of the cases, these are people who develop delirium following drug consumption. And for such manifestations, it doesn't engage 331. So this defense could only apply where the person is unable to consciously control themselves or be aware of their conduct. And this could lead to the most frequent cases. So we mostly have psychotic cases where consciousness is not obliterated, like someone who doesn't know that their act is bad. So it's for the same. It's certain that this would go to the court, and Section 33(1), as currently worded, limiting extreme intoxication to the defense of automatism, it is clear that this will be declared unconstitutional. That's the reality. Mr. Parent, could you please tell me in the text of Section 331 as it's currently worded, what changes you would make? What passage would you change? It's not complicated. 33.1 should define extreme intoxication. And this is done in paragraph 33.1. 33.1 should define extreme intoxication as intoxication akin to automatism or insanity. What I'm saying is that we'll simply be using the expression that was used by the Supreme Court in the Avio case. In that case, we talked about extreme intoxication that was related to mental alienation, bordering on insanity. So if we do that, all episodes of extreme intoxication will not pose a problem. So we'll find the rarest cases, as presented in Brown, cases where the person is in a state of automatism like a robot, and then there's delirium induced to substance abuse, very rare. It's only two. My career, I've spoken to other psychiatrists, they say the same thing. But this will also cover cases of psychosis, where the person following drug consumption develops ideas of persecution. The cases that Ms. Diab mentioned a while ago are delirium cases. So if we were to add to extreme intoxication akin to automatism, extreme intoxication akin to automatism and mental alienation, we find ourselves facing all possible cases, and I'm sure that at that point there will be no problem. Mr. Parent, I think I have a few seconds left. In the same line, when we read 4, we talk about the possibility of conscious self-control. But to be conscious of one's conduct, does that not cover the cases that you've mentioned? No, because Justice Kazira says so clearly in paragraph 50. It's not the same as a psychotic episode where the person's consciousness is intact. He says that extreme intoxication, which is akin to automatism, affects the consciousness of the person, consciousness of their actions. This doesn't cover cases of psychosis. It is written black and white in paragraph 50.
Thank you, Monsieur Fortin. Next, we have Mr. Garrison for 6 minutes.
Merci de la question.
Thanks for the question, says the witness.
Thank you very much, Mr. Chair. I want to thank all the witnesses for being here today. We've certainly had discussion about whether the change in the law are sufficient, but we also had discussion about whether other actions that are needed. So I want to particularly thank Ms. Foxall, for being here and for the work that your group does. And my question to you would be maybe an obvious question, but I think one worth allowing you some time to talk about in this. What are the obstacles that you're facing in the kind of work you're trying to do to raise the consciousness on campuses of consent?
Yeah, absolutely. I think in general, in the sexual violence prevention space within post-secondary communities, there's a really big lack of resources and support. And there's often only one sexual violence prevention advisor per campus doing the work of taking in reports, education, and so many more other tasks. They're amazing people doing such important work, but it's just too much for folks to be doing. So I think that's something we're trying to do in our work, creating that cross-provincial conversation. And I think, you know, when the ruling initially came out, there was so much panic and concern about what it actually meant. I know when I first saw it, I thought, okay, so someone can get drunk and assault someone else. So that, like, the term extreme intoxication is something that people really didn't understand what it means. And that misinformation caused a lot of fear. So I think creating that plain language interpretation of these things, and as someone mentioned previously, a communication strategy, I think would be really valuable because the legal jargon can be very confusing. And I also think that the people who are going to go and really try to understand what something means in the law are not the people who are going to cause harm. The people who cause harm may see a headline and think, okay, great, I can get away with things that I couldn't beforehand.
And in the work you're doing on campus, sometimes I know, having spent 20 years teaching criminal justice, there's a tendency for things to get siloed and for people to say, well, this group is already doing that work. So how are you finding your relationships with other existing groups and finding support for them to talk to their members about the message that you're trying to get out?
Mm-hmm. Yeah, there's so many incredible organizations and individuals who have been doing this work in this space for so many years. So we're so thankful for the work that they've been doing over the years. But yeah, it's really a lot about connecting, collaborating with those folks. We have bi-monthly meetings with the sexual violence prevention advisors from each university in Atlantic Canada. So we come together, talk about the issues, talk about challenges that folks are facing, and really connect and try to establish best practices across institutions, because there is so much important work that's being done. But it's just getting it out to different people and ensuring that we have the funding and resources to get those great programs out there.
Thanks very much. I want to turn to the Manitoba Prosecution Service, either Ms. Jules or Mr. Kotler. And I just want to be very clear before the committee. What you're saying is the changes that were made in C-28 do actually close the gap, and that you will successfully be able to use this law to prosecute in your opinion.
Thank you for the question. As Ms. Jules indicated earlier, you can never guarantee a result in a criminal case, and it's important to always remain conscious of the burden of proof beyond a reasonable doubt that rests upon the Crown in every prosecution. That said, there are a number of reasons for optimism in the application of this legislation, and Ms. Jules referred to some of them. The fact that the language of subsection 2 is inclusive, it requires only a foreseeability of risk that consumption could lead to a loss of self-control. There is some jurisprudential support for the idea that as the gravity of a potential harm goes up, then the public is endangered even if the risk of harm actually occurring is small. I think you can expect to see prosecutors making that kind of argument in these sort of cases. The test is objective, not subjective. So even if an accused says, well, look, I had no idea this was going to happen, that won't be the end of the analysis. There are another number of avenues that we will be able to look to in determining whether a reasonable person would have foreseen the likelihood of a risk. And then finally, in Brown itself, the court seems to accept this idea of inherently risky forms of self-intoxication, and Justice Kisira refers in particular to the idea of mixing alcohol with street drugs, and sort of suggests that that activity in and of itself may carry reasonably foreseeable harm. And this sort of goes back to what I was saying before, that some sorts of activities are sort of inherently risky on their face, such that any reasonable person would be aware that, you know, if I'm going to do this, I really need to start thinking about what I'm going to do to make sure that I'm not going to hurt anybody if things go sideways.
Thank you, Mr. Collar. Do you think that Bill C-28, in its requirement that the accused present expert evidence on the state of extreme intoxication, has raised the bar for establishing that in that particular case we're dealing with extreme intoxication?
Very briefly, Mr. Cotler.
Thank you, Mr. Chair. Well, as you know, the Davio decision some 30 years ago already placed the burden to raise the defense on the accused, and I should note, did so in relation to all general intent offenses, not just violent ones. But I mean, I think what subsection 2 does in this case is provide some guidance, some useful guidance to trial judges in terms of what sorts of things you have in mind that they should be looking at.
Thank you. Thank you, Mr. Garrison. Next, for our next round of witnesses, we'll go to Mr. Brock for 5 minutes.
Thank you, Chair, and thank you to all the witnesses for your attendance today and your testimony so far. It's been very, very informative and important to this committee. I'm going to turn it over to you, Ms. Jules. I distinctly recall you being cut off at the end of your presentation, and it was on the theme on how confident you were as a member of the Manitoba Prosecution Service that, notwithstanding some of the commentary from legal scholars, that this would make it extremely difficult for crowns across this country to meet the high threshold. That you didn't feel the same way, and you were laying out some steps, and I believe you got to the first step, and then your time had expired. So I'm going to give you the opportunity right now to finish your thoughts.
Thank you. I do think I got a little bit further in Ms. Diab's questions. So, but I think again we anticipate, first of all, as Mr. Kotler's pointed out, the onus is on the accused. Having said that, we believe that there is certainly expert and medical evidence that we would be able to call to speak about the inherent dangers of many of the substances. I mean, the substance that we see the most, that, as Professor Perront pointed out, that induces psychotic states, are crystal meth, and there is a wealth of evidence in terms of the inherent risk of those drugs and consumption of those drugs that we would be able to call. And then when we speak of the individuals, again, there is often going to be evidence that we can call in terms of the individual and their history and their knowledge of how they act when they've consumed dangerous drugs. So we do see a path to obtaining convictions in these cases. We think that judges and juries are going to want to hear that evidence and are going to accept that evidence, that they are aware of the dangers inherent in some of these drugs. That speaks to the foreseeability of what will happen when consuming, particularly if you're consuming multiple dangerous drugs, when you're consuming an excess of dangerous drugs for a prolonged period of time. It becomes, courts will accept that it is foreseeable that those actions will lead to a violent loss of control that will harm individuals in our communities. So yes, we are confident that we can make this case for those who negligently consume those drugs to excess and find themselves in a situation where they endanger the safety of other members of our community, and be able to hold them accountable with this legislation. I don't know. Just consult. Did you have a specific? No. Just
Nope.
making sure whether Mr. Kotler had any other specific
Okay.
technical knowledge that he wished to add.
Okay. The second area that I want to get into with the time that I have remaining is the overall impression that Canadians and victims groups, particularly women groups, I've engaged in a number of town hall meetings, and I have explained to them as a former prosecutor, these are rare defenses that are being used in courts across this country. But it was really small comfort to a number of these individuals because in their view, one case is too much. And quite frankly, despite that, they still have this overriding belief that alcohol alone could deem to be ultimately successful. Despite my best efforts to reassure them that the Supreme Court of Canada has made it abundantly clear in this decision that alcohol alone would not be successful, I have done some research and I've concluded that between the passage of the original 33.1 and the Davio case, there have been successful cases across this country where alcohol alone was the sole intoxicant. So do you feel, I'd like to get some commentary from the two of you, do you feel that Parliament missed an opportunity to codify, missing the opportunity to not codify that alcohol alone could be a bar to the advancement of this defense?
Thank you for the question. I think in determining where you want to go, you probably need to start with the Supreme Court's decision, which makes it abundantly clear that absent negligence, that is to say, let me back up. The court has taken a strong position that absent fault, we will not be able to enter convictions for criminal offenses. There are fundamental elements of an offense that have to be made out. And so if the science suggests that alcohol is capable of putting an accused in a situation where they no longer are acting voluntarily or where they lack one of the elements of an offense necessary to make out the offense, then unless we can show negligence in consumption, then they should not be convicted. So
Thank you.
I suspect that your question is best directed to a toxicologist or a neurologist or a doctor that is an expert in the area of the impact of alcohol.
Thank you, Mr. Kotler.
But I don't think that the answer isn't a legal question, it's a scientific question.
Thank you, Mr. Brock. To Mr. Naqvi for 5 minutes.
Thank you, Chair. I want to thank all the witnesses for appearing today and sharing your expertise and knowledge with us. I will go back to Manitoba Prosecution Services. I've got 5 minutes, and I think we've discussed all these things, but I'll see if I can bring it all together. Good for the record and for our deliberations later as well. Can you outline the legal analysis or legal test that you will work through in the old 33.1 before the Brown decision as the prosecution service?
How would it work before Brown? Well, it was a pretty short analysis. The Crown would analyze the evidence, see whether we could make out mens rea and actus reus. To the extent that an accused wanted to argue that because of intoxication they lacked the mens rea. I'm sorry for using technical lawyer language, but mens rea just means the fault component of the offense.
I think every single one of us is a lawyer here.
Oh, okay, very good. To the extent that the accused wanted to raise intoxication as a way of showing that they lacked one of the elements of the offense, then if it was what the law calls a specific intent offense, then that would be fine. So if you were charged with murder, If because of intoxication you didn't have the capacity to form a sufficient degree of intent, then it could reduce it to manslaughter, which is a general intent offense. But if, when it came to general intent offenses, because of Section 33.1, you would be foreclosed from arguing that you lacked the intent necessary for the offense, or that you had committed the offense involuntarily. So it was a fairly short process, and the focus of the prosecution would simply be whether the Crown could make out the offense, and that defense was not available. Now it is.
What changed because of the Brown's decision?
Right. So what the Supreme Court said was the problem with that approach is that you have to have a degree of fault to convict somebody. You can't convict somebody who, for example, went to see a doctor, got a prescription, took their medication, and had a completely unforeseen result and ended up doing something that they didn't even have any control over. So the legislation as it stood was not narrowed tightly enough to exclude those people, and the prosecution argued, okay, but the legislation shouldn't be read as including those people. It should only be read as including those people who took substances negligently in a situation where there was a foreseeable risk that they could hurt somebody if they took it. So it wouldn't catch those other people. The Supreme Court said two important things. First is, we don't agree with you that that's what the legislation says. It's written too broadly. It catches everybody. It's not narrowly tailored to just those people who exhibit that moral fault. The second thing they said, and what's sort of even more important for your purposes, is they hinted pretty strongly that were you to draft legislation that was narrowly restricted to those who were negligent in the act of consumption, that notwithstanding the constitutional concerns about convicting somebody for an offense that they committed when they weren't in control of their body, because of the very pressing concerns surrounding intoxicated violence, they suggested we may let that pass. And so that was the impetus for you to go back and see if you could put together a piece of legislation that did restrict liability to those who exhibited that degree of negligence, who consume substances in circumstances to a degree or to an extent to which there was a foreseeable risk that there could be a violent loss of control.
So in your view, did the Parliament got it right in a fairly short period of time to capture that concern of the Supreme Court the way we have drafted and passed the legislation?
From what I can say, it appears to me that you tried to follow the roadmap that the Supreme Court had laid out for you. And of course, whether there are ways in which the legislation could be improved, now that you have more time to think about it, I expect is what you're looking at now.
But from a gap perspective, from a prosecution service perspective, the gap that was left, has that been sufficiently met?
Very, very briefly.
Yes.
Thank you.
Thank you. I want to thank Mr. Naqvi. Thank you to all the witnesses for the first round. We'll just suspend for a minute or so just to get sound checks done on the second panel, and we'll resume right after. Thank you.
And what is your child's costume?
Okay, we're going to have to ask about the child's costumes afterwards, but that's okay. We are now resuming our panel and the next set of witnesses. We have Pam Rick. Am I saying that right? Or just Rick?
Just Rick.
Okay. Pam Rick, Director General of the Women's Legal Education and Action Fund, and Farah Khan, Executive Director of the from Possibility Seeds, both appearing by video conference. So hopefully you've been sound tested and you've chosen the right language on the bottom of your screen. If you want interpretation, floor, it's the option there. So hopefully that's all good. You each have 5 minutes. We'll begin with Ms. Khan. Ms. Khan, if you can unmute.
Oh, yeah, sorry. I'd like to begin by acknowledging that this conversation takes place across traditional territories of many Indigenous nations. I'm currently on the traditional territory of many nations, including the Mississaugas of the New Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, the Wendat peoples, and now home to many diverse First Nations, Inuit, and Métis people. Thank you to the House of Commons Standing Committee on Justice and Human Rights for inviting me to appear as a witness for its study on the subject matter of Bill C-28, an act to amend the criminal code, self-induced extreme intoxication. I'd like to thank Rebecca Aikong and Grace Barrick for helping me prepare for today's presentation. My name is Farah Khan. I have been raising awareness about gender-based violence, specifically sexual violence, for 25 years. I have been working in the field from a frontline worker with sexual assault survivors and now run a sexual assault center at Toronto Metropolitan University. This is an issue near and dear to me. Sexual assault continues to be the most underreported crime in Canada. The Supreme Court of Canada's recent judgment on the defense of self-induced extreme intoxication and resulting Bill C-28 have been grossly misunderstood by the public, from people to policy expert alike, people in my field. Public and community-centered responses are rooted in a lack of fundamental understanding of the decision and proposed new law, and we can do better. Members of the public, including myself, when we first heard the appeal and the decision, were scared. We were scared that this would allow self-induced and extreme intoxication to be a valid defense to sexual assault, giving people who do harm carte blanche to commit sexual violence without repercussions. But I know now, reading this and understanding the bill and understanding the decision, it's not true. As sexual assault and alcohol consumption have often been correlated, it's reasonable to have this initial fear. About 1 in 3 respondents to a gender-based violence and unwanted sexual behavior study in Canada stated that the most incidents of unwanted sexual behavior they were subjected to was related to alcohol or drug use of the perpetrator, with this being slightly more common among men than women. This view allows intoxicated people to get the idea that perpetuating sexual violence is okay, but it's not. And I worry that organizations, sexual assault centers, survivors are getting the idea that this somehow is giving carte blanche when it's not. Survivors may be less likely to report their cases if they're misinformed, understanding that this defense, and believe it'll be evoked easily when people are drinking or doing drugs. In 2019, the General Social Survey reported only 6% of sexual violence was reported to the police. I worry that this misinformation of this new defense may further reduce this already low statistic. To understand why this matter has been taken up the way it has, we have to understand what decisions actually say and why the S33.1 of the Criminal Code was deemed unconstitutional. In essence, S33.1, as it was, breached an accused person's right to life, liberty, and security of the person, and the right to presumption of innocence by holding them criminally responsible for actions committed while in a state similar to automatism. This is when the mind and body stop talking to each other. Think, for example, of sleepwalking, another form of automatism. This prevented anyone from raising the state of automatism as a defense in cases general to intent violent offenses, even when they could not reasonably predict they would reach the state when they were choosing to self-intoxicate. The holding is actually a progressive one, as it safeguards the well-being of those potentially suffering from addiction issues, many of whom come from marginalized identities that are already overrepresented and over-criminalized in the so-called criminal justice system. Contrary to what many people are saying online, on TikTok, from social media, and that part worries me the most as someone who works with survivors. I work with 16 to 24-year-olds. They were terrified about this. They were spreading misinformation. We need to do better about that conversation. And the thing was, the SEC was clear that drunkenness on its own would rarely result in a state similar to automatism. Therefore, the crux of the issue is the extent in which the consumption of drugs or alcohol prevents the user from having voluntary control over their actions. An accused would need to prove that they were in the state of extreme intoxication, drawing on expert advice. It would not be sufficient to show that they're really high or drunk. In other words, the accused would need to prove that they had no willed control over their actions at the time of the offense. The reasons for finding unconstitutionally lie in the fact that the old SS 33.1 would lead to convictions even when someone's completely lacked the intention, guilty mind, or voluntariness to commit a crime. If one's intoxication is extreme to the point of automatism, they may negate the requirement of both the mens rea, the guilty mind, and the voluntary wrongful act of the offense. The new S 33.1 allows individuals to raise a defense under very limited circumstances, consistent with the Supreme Court's decision. While the onus remains with the Crown to prove beyond a reasonable doubt that this accused committed the act, the burden is on the defendant to establish the defense of extreme intoxication on the balance of probabilities using expert advice.
Thank you.
The Crown had the opportunity to
Ms.
negate
Khan,
the use.
unfortunately, your time's up, but hopefully you'll be able to extract that in some of the questioning.
no
Over to you, Ms. Rick, for 5 minutes.
Thank you. Good morning. My name is Pam Rick, and I'm the Executive Director and General Counsel of the Women's Legal Education and Action Fund, also known as LEAF. I am grateful to appear before you today from Toronto, or Takaranto, which is within the lands protected by the Dish with One Spoon Wampum Belt Covenant. I'd like to thank my colleagues Jen Gamad and Kat Owens for helping me prepare for this appearance today. Founded in 1985, LEAF is a national charitable organization that advocates for the substantive equality of all women, girls, trans, and non-binary people. We do this through litigation, law reform, and public legal education, that is feminist and intersectional. Leaf was an intervener in the Supreme Court case of R.V. Brown, which struck down the former Section 33.1 of the Criminal Code. We intervened in that case to advocate for the equality of survivors of sexual and intimate partner violence, who are overwhelmingly women. When the Supreme Court released its decision, we were glad to see that it reiterated that intoxication alone is not a defense in sexual assault cases. We were, however, deeply concerned to hear the confusion and misinformation circulating online after the decision was released, particularly among young people. People were worried about whether saying, "I was drunk," was now a legitimate defense to sexual assault. The Supreme Court clearly said it was not. Leaf was at the forefront of efforts to stem this tide of misinformation alongside other gender justice advocates like Ms. Khan. Accurate information about what this decision meant was tremendously important, as is accurate information about what Bill C-28 means. The Supreme Court's decision created a very narrow gap in the law, something that would not be relevant to the overwhelming majority of cases where an accused person was drunk or otherwise intoxicated. The court laid out constitutionally compliant options for Parliament to consider if it wanted to address this very small gap. Bill C-28 was intended to fill this gap. As we said when it was introduced earlier this year, Leaf supports the amendments in Bill C-28. The changes to the Criminal Code represent a tailored and constitutional response in line with the Supreme Court of Canada's guidance in R.V. Brown. Education and training for justice system participants will be needed to ensure the law's proper application. Moving forward, however, we encourage committee members and all parliamentarians to resist focusing on the criminal law as an effective response to gender-based violence, including sexual violence. Canada's criminal legal system is a site of systemic discrimination. It disproportionately criminalizes Black, Indigenous, and racialized people, while at the same time failing to effectively respond to the high levels of violence faced by members of these same communities. In addition, the criminal legal system too often fails and re-traumatizes survivors of gender-based violence. We urgently need a fully funded intersectional national action plan to end gender-based violence and violence against women. As part of that plan, we need survivor-centered approaches to addressing and ending gender-based violence and violence against women. Survivors must have agency and choice in every step of the process. It is imperative to study, develop, and implement survivor-centered alternatives that move beyond existing legal systems. Alternatives like restorative and transformative justice models broaden the possibilities for justice, accountability, and healing. LEAF is committed to supporting this work through our own Alternative Justice Mechanisms project, which will identify legal barriers to alternative justice mechanisms for sexual violence and propose law reform measures to address those barriers. While this committee's current review serves an important purpose, I want to reiterate that the Supreme Court decision preceding Bill C-28 created only a very narrow gap in the law. Bill C-28 implemented a minor, constitutionally compliant response that follows the Supreme Court's guidance. The bigger issue is what this committee, this government, and this parliament must do to more meaningfully address violence against women and gender-based violence. More criminal law is not the answer. The answer is properly supporting and funding education, prevention, frontline services, and alternative accountability mechanisms that respond to the needs of survivors while working to end gender-based violence and violence against women entirely. Thank you.
Thank you, Ms. Rick. We'll go to our first round of witnesses, beginning with Mr. Brock for 6 minutes.
Thank you, Chair, and thank you to Ms. Rick and Ms. Khan for your attendance today and your participation in this important review of Bill C-28. I'm going to offer an opportunity for you, Ms. Khan. You had much more to say, I believe, in your opening statement, so I'm going to cede some of my time and allow you to complete your thoughts.
That's so nice. Thank you. I think the biggest thing that I want to just name, and I think Pam has actually already brought it up, is the two pieces that we see is that the court, we really need Justice Department to look at public legal education to address the misinformation that comes out. And I even think about the SEC decision that came out on Friday. People are so scared in the work, and survivors are. And when we don't have a good communication process that includes youth, because the most misinformation that's coming out about this was on TikTok. I saw thousands of young people talking about this and sharing this. And yet we didn't have a communications plan. So when this comes out, or when anything comes out that will affect survivors, we have to think about the accompanying a communications plan so that people are not spreading more misinformation, which will hurt survivors. The other thing that I wanted to name was that transformative justice processes need to be funded in this country, because justice, if we're saying that this is Ministry of Justice, justice goes beyond the legal walls. And right now it's not being funded. It's only being looking at a very narrow idea of justice, and we need better.
Thank you, Ms. Khan. And that, I believe, is a good segue to an area that I want to focus in on. I listened very carefully to your opening statement, and this is a question that I put to the previous panel in our first hour. I accept that across this great nation there is an erosion of trust when we look at sex assault victims and their responses to the criminal justice system. They don't see a fair system. They see a system that is rigged against them right from the outset. They see just the statistics alone, the underreporting, mistrust with police investigations, a mistrust in the relationship with Crown prosecutors, a mistrust with the judiciary, a mistrust with the probationary system. It's no small wonder that that small portion of cases that we as prosecutors would have the privilege of prosecuting, you would still have those difficulties in terms of securing convictions because of a number of issues, and largely it's a result of individuals, victims who just did not feel they were an equal participant in the process. So when we take a look at Bill C-28 and we take a look at the number of fears and concerns that victims have across this country, I totally agree with you that misinformation is eroding that public trust. And it is up to the government, in my view, and I think you both share this, to engage in a public educational system to reassure victims of crime, particularly in this area, that Bill C-28 does not open the floodwaters. To Ms. Rick's commentary, this is a narrow gap. We as lawyers, we as parliamentarians, we as academics, we understand that, but the vast majority of Canadians do not. So I'm going to be asking both of you individuals specifically, what more can your organizations do? What more can other agencies across this country do in addition to the government response of educating the public?
Sure, I will. I'll take a pass at this first. Thank you very much for the question. And before I get into what we are doing with the, I'll say, limited resources that we do have as organizations and advocates in this area, is that I think we have a tendency when we're talking about how well as a society we're dealing with sexual violence to look at conviction rates and reporting rates as indicia of whether or not we're doing a good job. And I really hope that one message I can convey here today, and that we do try to convey, that is grounded in a community and in the experiences that we've heard survivors share, is that looking at conviction rates doesn't accurately reflect how well we are dealing with sexual violence. I would like for us to more consistently look at how survivors feel about the accountability that they're able to obtain, the healing that they are able to engage in when they've experienced sexual violence, and using that as a metric for how well we're doing, and offering a wide array of options for survivors to choose from about the path to justice, accountability, and healing and support that looks right for them. to address the question of what more we can do. Again, I run a not-for-profit. I know that Ms. Khan operates in similar spaces. We certainly do the best we can with the resources that we have to reach as many people as possible. And part of what we did, actually working with Ms. Khan after these decisions came out, was to deliberately go to spaces where young people in particular are interacting, going to Instagram, going to TikTok in some cases, and trying to share information as a trusted resource. And we are that as LEAF, I believe, given our history of 37 years of advocacy in this space for the legal rights of women, girls, now trans and non-binary people as well. So we try to reach as many people as we can in the spaces where they are. And I think that's an important fundamental aspect of the work that Ms. Khan does as well, which I would invite her to speak to.
Thank you. Thank you, Mr. Brock.
Thank you, Chair, and thank you, ladies.
Next, Mr. Naqvi for 6 minutes.
Thank you. Thank you very much, Mr. Chair, and Ms. Khan and Ms. Rigg. It's really good to see you both. Thank you for the incredible work you do and all the guidance that you've given me in the past in various ways that we have interacted on exactly the same issues, and feel like we continue to have the same conversation, unfortunately, again and again and again, which tells me that we have far more work to do. I'll start with Ms. Rigg on the legal side of things, but I do want to pick up on the next steps that both of you articulated. I think it's important conversation to get that on the record as well. Ms. Rigg, you mentioned that you were involved in this case. LEAF intervened. Thank you for that. Can you speak to the gap the Brown decision created, and in your view, how does Bill C-28 meets that gap, or more could have been done in that regards?
Thank you, Mr. Naqvi. I'll take the opportunity to reiterate that it was an incredibly small gap that the Brown decision created, and will emphasize again that simply being drunk or being high is not a defense to crimes of general intent, including sexual assault. What the Supreme Court did here was strike down an unconstitutional provision that prohibited in all circumstances people from raising the defense of extreme intoxication akin to automatism as a defense to crimes of general intent, again, including sexual assault. And what Bill C-28 did was it took a look at what the Supreme Court said in its decision about what constitutional responses might look like. And it chose to implement one of those two options that would comply with constitutional rights, which are important. The rights of the accused are important and to be respected, of course. And the implementation of the provisions in Bill C-28, I think, strikes that balance between the rights of accused persons and the rights of women and girls and all those who experience gender-based violence to be free of violence. So it provides that pathway where there is some moral blameworthiness in conduct, and also allows for individual circumstances to be taken into account in the adjudication of these cases, which is why we have found it to be a tailored and constitutional bill.
Ms. Rigg, you were consulted on this bill.
Yes, we spoke with the Minister of Justice's office.
What advice or what guidance did you impart when you were consulted as it relates to Bill C-28?
Well, we felt that if the government was going to move forward with a legislative response to the Brown decision striking down the former Section 33.1, that this was the option that ought to be pursued, as opposed to a second option that was offered up by the Supreme Court of creating a standalone offense of extreme intoxication effectively. This is, I'd put it this way, it's sort of a pared down version of the former Section 33.1, which allows some nuance and tailoring in the consideration of how the provision applies.
Ms. Khan, I'll come to you, and you talked about, in your words, was a gross misunderstanding of the Supreme Court's decision, and you're in this space, you work in a university setting. I just cannot imagine the kind of gross misinformation that you must have seen in light of that decision, which probably amplified already pre-existent misconception that exists around sexual violence, sexual conduct, and its intersection with alcohol and drugs. Can you speak to that experience and how you were able to get the correct information out and negate some of those abhorrent views that may exist out there?
Yes, so 71% of post-secondary students have been subjected to or witness sexual assault and harassment, 71%. And many of that includes alcohol-facilitated sexual assault. So I had survivors during the first time that it was appealed and then the Supreme Court decision come into our office in tears, come up to us in trainings saying, well, I guess I can't report. No one's going to believe me. He's going to get off. Say in workshops that there's no point of reporting because no one is going to go forward with this because now they can do it without any repercussions. And so it was a consistent thing that we actually had to change the way we did our trainings. And I am a part of the federal government funded project called Courage to Act, which is leading the conversation of gender-based violence at post-secondary universities and colleges across the country. And we were working with organizations from across the country having the same conversation where they had survivors coming in terrified that they no longer could report, or if they had reported, that during the trial that it'd be pushed out because of this decision. So what we did is we actually worked with Pam, worked really closely with LEAF and actually approached them and talked to the Ministry of Justice and said, there's a problem here. Can you give us more information that we can have this? And you should not need a law degree, because most survivors don't have one, to understand decisions that the SEC makes. And that's the problem we have a lot of times. And so it's not that people aren't smart, it's not people don't know things, it's that they know other things. And so making sure that it's plain language, making sure it's accessible was really important to us, making sliders on Instagram, talking to our peers. But I think there's a big challenge too, is that social location impacts the ways in which people feel safe to report, the way people are criminalized. So another part of that too was talking about what could be done differently with also people who have sexually assaulted someone, alcohol facilitated sexual assault. And so I would say to you all is that we need to invest also in accountability counseling and work with men specifically who have committed sexual assault, young men. Because if women between the ages of 16 to 24 are the largest age group that is targeted for sexual assault, that means that majority of that is done by their peers. And so if we're not doing that work, that's important.
Fortunately, we're out of time for that. Monsieur Fortin for 6 minutes.
Mr. Fortin, 6 minutes. Thank you, Chair. Thank you, Ms. Rick, Ms. Khan, for being with us today. Ms. Khan, my colleague, Mr. Nadvi, asked the question I wanted to ask. I was also interested in knowing how people perceive CE28. The issue of correction that the government intends to bring to the interpretation of what should be a defense to some crimes related to extreme voluntary intoxication. You talked about TikTok. I understood some of the answers you gave. That is, there's a negative effect that could cause victims of sexual crimes to be less likely to denounce their aggressors. They feel that they will not be believed and that their aggressors will not be found guilty. So that interests me as well. So once you explain to people, because I imagine that you have some ladies who come and see you and talk about crimes they've been victim of. Once you've explained the provisions of 33.1 and the scope of this section, do people understand the rationale of this? Do they understand that there's never an excuse to any crime that they may be a victim of? What is the reality on the field? When do the victims understand the scope of Section 33.1?
I love this question because this is, the crux of the issue. So I travel across Canada and America actually as well, talking about sexual assault and consent with young people. And the biggest issue that they're challenged with is alcohol facilitated sexual assault. It's the number one thing that young men will say, well, if I'm drinking and she's drinking, is this okay? And so this initial decision made it more complicated because people didn't have the answers they needed or felt as if it was shutting it down. So we do make sure that we've included provisions within our training and conversations one-on-one with survivors. So train our staff, have those conversations of how to talk about it when they bring up these things. And because for a lot of people, they feel like the sky is falling. They feel like it's the worst thing that's ever happened to them. And for young men, they're already feeling confused about consent because we don't have comprehensive sexual health education in Canada that actually teaches young men and young women and all genders, because all genders are sexually assaulted and all genders can commit sexual assault, what their roles and responsibilities are, how to have sexual communication, what is masculinity, what does gender have to do with it. So a lot of our work is unpacking those. I will say this, there's a moment of relief. I can't describe the face that I see in front of me when I'm doing a counseling appointment and a survivor says to me, you mean I can still talk to someone? Yes, you can. And luckily in Ontario, we have the Independent Legal Advice Pilot Project where survivors can access up to 4 hours of free legal advice, but that doesn't exist in every province. So they have nowhere to go. So this is an access to justice issue. This is an access to public legal education that I would say to you, please invest in talking to people who work with young people around this. Invest in people who are doing the work on the ground. Bring us in. We want to talk to you about this stuff. And I would say the Justice Department has been great about conversations around it, but they need to have more resources to be able to do what we need to happen around communication.
Merci.
Thank you. First of all, were you consulted, Ms. Khan? We understand that Ms. Rick was consulted, but were you consulted by the representatives of the Department of Justice before C28 came into force? I understand the answer is yes, correct?
Yes, I was. I did have the opportunity to speak to members of the Justice Department.
Est-ce que vous êtes...
Are you of the opinion that the current version of Section 33.1 responds to the concerns you raised with the minister?
Yes, I do. It actually gives provisions and ways in which people could go about to address this. So I think absolutely it does. But again, it's how we communicate those and how we make sure that not only the public knows, but also Defense Counsel understands it, that Crowns understand it, the police understand it. Because what we've seen time and time again is survivors coming forward with stories that they say, I reported to the police and the police said, oh, I don't think this can go forward, or they say misinformation to a survivor. So this is not just about public as in the general public. These are people that work within the court system, judges, lawyers, also police, people in frontline services, victim witness. We need to ensure that they have the education to understand this. So yes, I agree with the provisions, but I think we have to go farther. Provisions aren't enough. It's how we apply them.
Oui. Donc, en résumé.
So in summary, a good communication plan will be important on that aspect.
Merci, Madame Khan.
Thank you, Ms. Khan. Thank you. Thank you, Ms. Rick.
Thank you, Monsieur Fortin. And next to Mr. Garrison for 6 minutes.
Thank you, Mr. Chair, and thank you to both the witnesses. I think it's been very useful to broaden the conversation beyond the specifics of legalities. And I think you've made the important general point that our priorities are sometimes revealed by our spending, and that we spend a lot on incarceration and we spend a lot on the criminal justice system. We don't spend so much on prevention and education. So I saw Ms. Rick nodding a lot during Ms. Khan's presentation, but I'd ask you to just comment on that relative prioritization of where we work on the issue of sexual assault.
happily. And yes, I was nodding along quite a lot. I find I do that when Farah is speaking, because she's right. We do need to prioritize better funding for prevention and education, and where sexual assault has occurred, support for survivors, and as Ms. Khan correctly pointed out, also support for and accountability for people who have committed sexual assault, especially young people. We really need to have in place a fully funded national action plan to address gender-based violence and violence against women. Funding for prevention, for education, for systems outside of formal legal processes to support survivors in finding the accountability and justice that works for them is critical. So I would like to see greater investment in the sector in delivering on those important issues, which would also align with an earlier committee member's line of questioning about what we can do, of course, where we are to help educate the public. We do need funding and support to be able to do that.
And of course, I guess it does tell us a lot that this work is left to women-led NGOs in our society. And my own experience for many years working with non-government organizations was there was lots of project funding, but there was rarely money to keep the lights on. The core funding issue was really a hard one for the NGOs. So you can go to people and say, I have a good idea, but you can't run those good ideas without the core funding. So Ms. Khan, maybe I'd ask you to comment on that challenge.
That is a challenge near and dear to my heart. You know, I've been working in the field of not-for-profit. It raised me. And the thing that always is that we don't have the money to do our core services. So you're chasing after grants after grant. People are living on shoestring budgets. There's an expectation to do tremendous, important work that actually will help society thrive. You know, you want a thriving economy, you have to address violence. You want a good education system, you got to address violence. You want non-carceral approaches and other things to address violence and anti-oppression, you have to address this. So we need to have core funding and stabilize the sector. The sector needs to have the core funding it needs to do the work, including work with all parties involved in sexualized violence, respondents, complainants, survivors, families. I think the thing is that we oftentimes see the priorities skewed where people are like, you know, we have to focus on all these other pieces, but unless you have people that feel safe, that people feel like they are nourished and nurtured, we will not move forward. So I absolutely think that. I think too that a big part of it is also, again, expanding what we see as justice. If the justice system if less than 10 to 6% of survivors are reporting sexual assault, then we need to support those other survivors who are not. So where is the money going to support them? Because we look at the money that's being spent on carceral approaches compared to supportive healing approaches, it's very different.
Thank you. Ms. Rick, on the same question of core funding for the organizations who do this important work.
Again, I am in very enthusiastic agreement with Ms. Khan. It's a hugely important issue, and I speak especially as a national organization where we don't have options to access, for example, core funding that might be offered at the provincial or territorial level. Having the ability to know on a year-over-year basis that we have a certain pot of funding that will allow us to pursue the work that I know is important to members of this committee, as well as members of the communities for which LEAF advocates. We need to be able to have the stability and resources to do that on an ongoing basis. And every grant that we have to pick up pens to write and submit applications for takes us away from doing that core important work.
No, I have very little time, but I want to broach the question of the differential impacts of sexual assault and our efforts to combat it on marginalized women, both racialized and poor. Maybe I can just ask that question generally quickly to both of you, Ms. Khan.
Yeah, our social location, our race, our gender, our sexuality impacts the way in which we are believed. So are we going to approach the police? If our community has been criminalized by the police time and time again, we are not. So Muslim communities, Black communities, Indigenous communities, South Asian communities, racialized communities, queer communities may not feel safe to report. and then let alone be access services or be seen as someone who can get the help that they need. So it absolutely impacts it. We have to look at this from an intersectional approach and recognize that so many people don't access support. And I would add gay men in there too. So many men come to our service, and what's interesting is, so I work in an all gender service where before I worked just with women, and it's 7 years now. It's lightning rod seeing so many men come forward and say, I was sexually assaulted, I need support. And before there's nowhere for them to go, and now there is.
And I know there's very little time, but Ms. Frick, perhaps a quick comment.
I don't know how many times I'm allowed to simply agree with Farah, but I will agree with her. And just I'll leave it at that. I can't put it any more eloquently.
Thank you very much to both witnesses.
Thank you, Mr. Garrison. Next, we'll go to Mr. Van Popta for 5 minutes.
Good. Thank you, Chair. Thank you, witnesses, for being with us, for the important work that you do. Earlier in the study, we had witnesses before us at this committee who talked about the trauma that women face in sexual assault trials in a criminal law setting. And we heard that, and I think that you reiterated that a very small percentage, like 6% of sexual assault cases actually get reported, even fewer get prosecuted, and of course even fewer end up in convictions. And now we have a defense of self-induced extreme intoxication available once again. We heard from witnesses earlier today who are Crown prosecutors working in this field, and they said that they expect that there will be more accused people who will raise this as a defense. So just a wide open question. Could you comment on that? What does this do? And for either one of you, maybe Ms. Khan, because my follow-up question will be for Ms. Rick. Just comments on generally, what does the availability of this defense do to the trauma of victims in a criminal court setting?
It will only do what we put into it. So what I mean by that is, if we don't have clear communication, if we're not educating survivors, if we're not providing them access to justice that's outside of the Crown so they could talk to a lawyer independently to understand, then they're going to be less likely to report, because we're allowing influencers, people who are not experts on this, start speaking about it and taking up the loudest space. And so we have to do misinformation campaigns. And right now, like disinformation is one of the biggest problems. I think in terms of survivors going through a court case, someone said before that, there's an erosion of trust in the court system by survivors. It's always been there. It's not eroded. It's always been there. Survivors don't trust a system that is not made for them. Survivors don't trust a system that is set up to put them on trial and not the person who's harmed them. So we need to do better, but we also need to have more access to justice, processes for them, and more information for the general public.
Good, thank you. So, Ms. Rick, earlier in this study, I think it was last week, we had some law professors here giving evidence, including Dr. Kerry Frock of the University of New Brunswick and chair, I think, of the National Association of Women and the Law. That organization is critical of Bill C-28 and the revised Section 33.1. And in discussing C-28, she said this. She talked about the, quote, problematic aspects of the bill, which we fear will pose nearly impossible hurdles for the prosecution of intoxicated perpetrators of violence against women, close quote. And then she went on to say that there are other alternatives available that Parliament could have followed, rather than just necessarily one or other of the two options that the Supreme Court of Canada gave us, including reversing the onus on the negligence aspect of the bill. What do you say to that?
Well, I appreciate the opportunity to be able to speak to this. My concern with any sort of reverse onus at this point is the large risk that the Supreme Court would find that to be unconstitutional. And what I do appreciate about how this particular bill was tailored and implemented is the nuance that it allows to be brought to the consideration of the defense. So all the relevant factors that are able to be taken into account and properly taken into account ensures, I think, the constitutionality of the legislation. As to whether this sets too high a bar or a nearly impossible bar, I only caught part of the last panel, but I believe you had representatives from the Manitoba Prosecution Service who were speaking to the extent to which they thought that it would be possible to prosecute under this new provisions, or these new provisions that have been implemented by Bill C-28. So I defer to their prosecutorial expertise on that particular issue.
Good. Yeah, that's a fair comment. So thank you for that. In 30 seconds, I'm reading on the LEAF website about the criminal law disproportionately discriminating against marginalized people. In the few seconds that are remaining, could you comment on that? Like, you're not expecting a different balance of proof depending on race, for example, I'm assuming.
No, of course not. But what I do think is that people, particularly at this committee, and all parliamentarians, need to understand the ways in which racialized people, Black, Indigenous people are disproportionately criminalized. And you need to look no further than the statistic that 50% of federally incarcerated women in this country right now are Indigenous, notwithstanding that they represent under 5% of the Canadian population.
Thank you, Mr. Van Popta. Next, we'll go to Ms. Dillon for 5 minutes.
Thank you, Mr. Chair, and thank you to our witnesses for being here. I will start with Ms. Rick. I was going to ask you this question, but Mr. Van Popta already started. You spoke about the importance of constitutional rights and how they are being protected with this legislation, that important balance it's being looked at, and you spoke also during your opening statement about marginalized people, people of color, Black, Indigenous, being adversely affected both on the victim side and the accused side. Can you please tell us how this legislation, how this approach will help in these kinds of situations? Because as you've stated, it's important to look at both sides and see that there's a balance where rights are protected for both the victim and the constitutional rights of the accused. Thank you.
Right, and that's exactly what our charter requires. It requires the protection of rights of accused persons, and also provides for the protection of rights of equality deserving groups, including women and girls. And the particular provision, section 33.1 sub 2, that I think is important to this legislation is, again, looking at all of the relevant circumstances of a particular case, and those being brought to bear on determining whether or not somebody has successfully, or whether the prosecution is successfully meeting that threshold of proof beyond a reasonable doubt in light of all relevant circumstances, which will allow things like addiction issues, mental health issues to be taken into account. And I think also acknowledges exactly what I was talking about, which is the ways in which the criminal system disproportionately comes to bear on Black, Indigenous, and racialized people as well. It's not privileged white women who are being stopped in the street and who have been carded. It's not us who are being disproportionately charged, being brought into contact with the criminal justice system. It is members of those more marginalized communities, and I think that's something that always needs to be front of mind when we're talking about criminal law.
Thank you for that. And what would you see as alternatives? You spoke a little bit about getting people out of the criminal justice system and having more healthy, and we've heard throughout testimony in this committee that holistic approaches need to be looked at. Do you have any suggestions? What do you envision this as this being? Thanks.
I envision fully funding, as Ms. Khan already said, restorative justice, transformative justice processes of community-based accountability mechanisms. And as somebody who has been, I think, on the front lines of some of that, Ms. Khan may be well placed to actually share some of those experiences and that expertise on this specific question.
I was actually going to ask Ms. Khan if she could follow up as well and give us her opinion as well on my questions I asked you previously, and to carry on with what you said. Thank you, Ms. Khan.
Sure. Thank you to both. And everything Pam says, I agree with. So we'll just like co-sign everything on there. I would say around transformative and restorative justice. So, we have Courage to Act released 2 guides on working with people who've caused harm and working from a non-punitive approach around accountability. And I would say those 2 things really need to be looked at. Too often we create processes that actually don't heal communities. We can't create an island where all the people who commit sexual violence go. They are amongst us. And we have to build resources, opportunities, training, so people can do the work. I've been witness to accountability counseling where a young man was, he was found that he had sexually assaulted someone. And he said, instead of going through an investigation process, we said, would you go through accountability counseling? And he agreed. And he went through it. And at the end, he was able to name, yes, I did that. And this is why. And this is what needs to change within me. And 6 years later, we spoke to him, and he was a part of a podcast we just put out where he and the survivor talked together about what was meant going through that process. We need more opportunities like that, because the thing is that there was actual change there. There was a change of mindset. There was a change, I won't do this again. This takes more resourcing and a whole systems change, but it's where we need to go, because this is not working. The current criminal legal system, I'm not going to call it justice, the current legal system isn't working for survivors and respondents. So we need to do better and invest in those transformative restorative justice, but that's going to take funding, resourcing, and being creative, which I hope we can be.
Thank you, Ms. Dillon. Next, we'll go for 2.5 minutes to Monsieur Fortin.
Merci, Monsieur.
Thank you, Chair. Ms. Khan, I find you very optimistic by saying that we can do it. Very well. I would like you to take you a bit further. Should victims not participate more in criminal trials? Of course, when there's a civil trial, they participate. But in a criminal trial that involves the Crown against the accused, the space we give the victims, is that not too small? Is it not possible to allow victims, maybe not oblige them because some of them would not like to, should we not allow them to participate in all phases or all stages of the trial? Maybe put questions to the accused, maybe with the representation of their lawyer, maybe participate in the famous plea bargaining. In your opinion, is it not possible to improve the way victims are heard in a criminal case?
Our Canadian laws are quite good around sexual violence and consent. I think the challenge is how they play out in court. And so I think we need to look at that, and that includes better training for lawyers when they're strongly encouraging lawyers, judges, anybody that's part of the criminal legal system to be trained about sexual violence, including this provision. I think one of the other things that we really need to see is that the independent legal advice. So although I think we can change it, I think survivors really need to talk to someone that they have as the independent person that's just for them during that process. The respondent gets that, the defense gets that, but the survivor doesn't through that process. So that's why the independent legal advice pilot projects are so important, and they shouldn't be pilots, they should be permanent. But Pam, I think you're better to speak to this than I am, because I'm not a lawyer.
Madame Rick,
Ms. Rick, in the next few seconds that I have left, do you have a position on that?
I do think we need to ensure that survivors, and in the context of the criminal system, of course, they're legally called complainants, do have access to that independent legal advice, are given proper information throughout from Crown Prosecution Service, from the Victim Witness Assistance Program and equivalents outside of the province of Ontario as well, to ensure that they have a working knowledge of exactly what they're going into and exactly what this process is going to look like, so that they can make informed decisions and informed preparations along the way.
Thank you.
Merci.
Thank you.
And last, we have Mr. Garrison for 2.5 minutes.
Thank you very much, Mr. Chair. Earlier, I think it was Ms. Khan that you made reference to the Nodlovu decision on Friday with regard to mandatory registration of sex offenders. And I wonder if you see the same kind of fear and misinformation spreading through the same channels as we saw with the previous decision.
Yes, I wish I could put my DMs on display right now on Twitter because so many survivors are messaging me in a place of fear. And I actually wrote to Justice today being like, I need better information to be able to plain language explain the decision and why the sky isn't falling. And the thing is, I shouldn't have to, I'm ready to go back to school to go get my law degree at this point because I shouldn't have to get it. But we need, when these decisions are made, if the government knows they're coming, then we need a communications plan that's plain language, that really speaks to folks and speaks to young people who are doing the work, that can communicate to their peers. It's not enough. Pam and I are not young enough. Sorry, friends. We may look it, but we're not. And we need to have young people like 18, 16 talking about this in plain language. And it's really too bad because in this moment, we need stronger provisions around this. And we failed again, the public, I think. I know Justice is doing so much and has low resources themselves. So this is no blame or shame. This is just another thing to think about.
I would direct the same question to Ms. Rick. Are we, I guess, committing the same fault here on the second Supreme Court decision?
I'd say that we do need to have better education and information sharing about this. And I know that the Supreme Court in cases like this, of course, gives a bit of a heads up that a decision is coming and the implications of it can be sort of thought through and plans can be made in advance where there's enough resources to do so. And I think it's important to dedicate the resources to doing that. So it's not, again, to your earlier point, left on the shoulders of predominantly women and gender diverse led not-for-profit organizations to do the public education that is so urgently needed to ensure that we are providing accurate information about what the law is.
And again, I thank both of you for being here today. I think you've had very important things to say that will inform our report, I hope. And I thank you, Mr. Chair.
Thank you, Mr. Garrison. I want to thank both Ms. Khan and Ms. Rick for your great testimony today. That concludes our meeting for today. I just want to remind our members that this Thursday's meeting will be canceled because it's the fall economic statement at 4 o'clock. So I think all committees are. Maybe one day. No, not today. So I will adjourn the meeting and see you guys all next Monday. Thank you.